the apex of the justice delivery system is the judge, or are the judges. And their role in ensuring access to justice in Ghana is very crucial. And therefore, it is necessary for us to position ourselves to understanding the role of the judge or judges in granting access to justice. And to help us do that is our own sister and colleague, Mrs. Victoria Barth. She's been a feature at the conferences since when? About 2005. So now she was called to the bar in 2002 and began his legal career with the Attorney General's office as an assistant state attorney. And she moved on from there to join SO&Associates, where she has risen to now the position of a managing partner. She is married to Mr. Barth, of course. Mr. Ben Barth. But then she's a colleague, adjunct lecturer at the Ghana School of Law, and she takes delight in taking speaking appointments. So if you have any instance where you might need her, she's available. May we welcome our sister, Mrs. Victoria Barth.
Thank you very much, and thank you for your endurance between the Abobitade and the Abobi whatever. Pardon me. I actually had that one, the one with the coconut milk. I enjoyed it. And the stellar presentations that have preceded. I am grateful that you are still staying here. And thank you for mentioning the married part. Marriage is an endangered species now. Well, yes, it brought me to Accra, and it was good. And I always find that it is important to add it to my resume so that I will encourage others on that path, that you can have a career and also add that. Yes. So access to justice, or the judge's role in access to justice, was the topic that was given to me, and I took some liberties to tweak it and say a practitioner's perspective, because it's such a broad topic. Access to justice is not just the ability to mount an action or bring a claim, but it could do even with how well the courtroom is furnished, your physical access to the building, the provision of legal aid, among others. I am going to concentrate specifically on the role of judges in creating or enhancing the access of citizens to justice. And not just any kind of justice, but justice that comes with certain key elements. And so I chose a particular definition which I thought summed up what my ideal of access to justice is. And it is by Bob Blaves. Can I remove this? Let me follow my predecessor. So it's from an article in 2018 called "What Do We Mean When We Say Access to Justice?" And the author says, a person or entity facing a legal issue, that is, they could benefit from or be hurt by a legal action, has timely and affordable access to the appropriate level of legal assistance and a fair and efficient court or process to resolve disputes so that they can understand and make decisions about their legal issue, get a fair and cost-effective resolution on the facts and applicable law, and feel like they were heard, were treated fairly, and understood the outcome. So what do I take from that? Fair trial. That would mean a fair and public hearing, except where otherwise provided by law. It means that it would be timely, that if it's going to be fair and there are different sides to the dispute, then we would have an independent and impartial judge. And that judgment, again, pronounced publicly, cost-effective process, fair outcome on the merits of the legal issue, sound judgment or outcome. Earlier, His Lordship talked about enforcement being a major challenge for us practitioners. And it's for a whole lots of reasons. But he touched on a Supreme Court case which has now given a practice direction on how clear orders of the courts must be. And that is because you and I can go through law school and pass and not understand certain judgments that emanate from the courts. And we hope that that practice direction and the judge's judicial oath will be taken seriously. Because there's no point having a timely and apparently fair trial only to come to an outcome that you cannot grapple with or even enforce. So these key elements are both substantive and procedural. If a party gets an objectively fair result, but the process did not allow them to understand or believe that they got a fair deal, that party will not believe that justice was served. There are a whole lot of laws that govern the powers of a judge and what their function is. So I call it the framework for a judge to execute his mandate. And obviously it starts with the constitution that creates the Judiciary Courts Act, again, which also sets out the composition of the various courts, their jurisdictions, other statutes, judicial precedents, such as binding decisions that are on the procedural rules, which provide the step-by-step approach for the process of adjudication. Case law, code of conduct for judges and magistrates, judicial service regulations. I'm sure I've not exhausted them, but these are some of the main laws. So, because of how broad the topic is and how short this time is, because I want to avoid the situation where when I finish, you don't have enough time to ask questions. I hope you do have questions or comments. And so I picked on a few provisions from some of these legislation that I listed, which I thought were relevant to the question of access to justice. So you have, for instance, Article 19(1) of the Constitution that states that a person charged with a criminal offense shall be given a fair hearing within a reasonable time by a court. Then we come to the Evidence Act. Section 1784 also provides that the act should be interpreted and applied to achieve a consistent law of evidence and the most just, expeditious, and least costly administration of the law. Civil procedure rules, I'm sure we're all familiar with this one. We cite it a lot when we bring applications and it favors us. So Order 1 Rule 1.2 of CI 47 says these rules shall be interpreted and applied so as to achieve speedy and effective justice. And as if speedy was not enough, they add, avoid delays and unnecessary expense, and ensure that as far as possible, all matters in dispute between parties may be completely, effectively, and finally determined, and multiplicity of proceedings concerning any of such matters avoided. So we are not just interested in speedy, but we're also interested in quality justice. And then we have Order 41, Rule 2, which deals with the judge's duty to deliver judgment within 6 weeks. How many of you have gone to the Court of Appeal recently or the Supreme Court for hearing or to take a date for judgment? May I see? Oh, really? Very well. Was it within 6 weeks? Pray tell. No. Okay, we'll come back to that. And where a judge fails to comply, any party to the matter may in writing notify the Chief Justice of the fact and request that a date be fixed for the delivery of the judgment. Upon receiving the notice, the Chief Justice is to fix a date for the delivery of judgment by the court and notify the court accordingly. And it shall be the duty of the court to ensure that judgment is delivered on the date fixed by the Chief Justice. We'll soon see what happens in Rwanda and other places. But essentially, the delay on the part of the court does not invalidate the decision. And that can be both a good and a bad thing. So again, I picked a few provisions from the Code of Conduct for judges and magistrates, which is their equivalent of our professional conduct and etiquette rules. and I'll breeze through them so that we can get to the fun part. A judge shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. A judge shall not initiate, permit, or consider any ex parte communication concerning a pending or impending proceeding, except that where circumstances require, an ex parte communication is authorized when it does not deal with substantive matters and is for scheduling or administrative purposes or emergencies, provided the judge reasonably believes that no party will gain a procedural or tactical advantage as a result of the ex parte communication, and the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and allows them an opportunity to respond. So we're all familiar with this. Then 8, a judge shall dispose of all judicial matters promptly, efficiently, and fairly. I want us to keep these 3 words in mind as we go and look at how the rules of procedure and substantive law are applied by judges in their role in advancing or enhancing access to justice promptly, fairly, efficiently. You also have this provision on administrative responsibilities. I'll skip it. And then self-policing. I like this one. I wish you could see the picture. Well, it says, I'm not among. And that is the general attitude, not just among judges, but even lawyers, because we also have an equivalent provision in our code of ethics, which requires us to expose and report misconduct by fellow colleagues. Here, the judges have a dual duty, not just to report their peers, where they have knowledge of facts indicating a substantial likelihood that another judge has committed a violation of the code, which raises a significant question about that judge's honesty, integrity, trustworthiness, or fitness for judicial office. Then they also have one which has to do with lawyers who appear before them. And remind me if I do forget, because we'll be telling a few, anecdotes. And where a judge before whom parties appear neglects this duty, where lawyers have sworn to affidavits and lied on oath, and you even go the extra mile. Well, let me not say you. I'm getting ahead of myself. Yes, let me put this up first. Oh, and it's not coming. I need my disclaimer to show before we start the movie. Right. I'll read it to you. Disclaimer. All anecdotes or events referred to in this presentation, though based on real people, are entirely fictional. Misrepresentation of or gossiping about the matters discussed or mentioned in the presentation, this presentation, will be injurious to your health and peace of mind. Please be advised accordingly. And it's PG-13. Yes. So we just saw that provision. And with every, perhaps I should just go on to my next slide. Yes, so now we look at the obstacles to the judge's ability to promote access to justice. And remember, I said I'm speaking from the practitioner's perspective. So I want to situate the obstacles to the experiences which I believe may be common to us. And then we can look at some recommendations. So there's this category that I call the judge-induced, because it is personal to how that judge runs their court and administers or dispenses justice. First one is lack of integrity. And for me, integrity is not just about honesty. It's about an attitude of diligence or the lack thereof, among other things. So poor work ethic, failure to adhere to timelines, including being punctual. There are certain courts that we all accept. This court sits at 10. Not because we are aware that there's a special dispensation from the CJ, but we have all come to accept that, as for court so and so, he or she will sit at 10. Well, of course, there may be some who come at 10, and between 10 and 12, business will be done. We won't complain about that. But more often than not, we find that the ones that sit at 10, not much also gets that. Please remember the disclaimer. And then Failure to adhere to timelines. You give a timeline for ruling again, and I'll come back to that provision that gives 6 weeks. You and I, when we fail to file processes, we know what the consequences can be for our client and ourselves. And I'm not saying we are saints. We all fall short. Sometimes the pressures of the work make it so. Inability to adapt and use technological resources or e-justice. You and I go to court and we're told there's no proof of service on the docket. From my understanding, every process when it's filed is scanned, at least those of us who are using the courts who have these resources, and the judges are supposed to receive soft copies. So unless the system is malfunctioning, and for a judge who has taken the trouble to review their dockets before coming to sit, granted that I may file something that morning which may not get to you, but what was filed the week before, if indeed the system is working, what's that guy's name? The system is working. That's just by the by. If indeed the system is working, when I appear before you, it shouldn't be a total reliance on the physical document on your docket alone, so that you hand it over to your clerk and you say, I do not have it. And that becomes a reason to adjourn. Whereas maybe if we clicked a few buttons on your laptop, we would see that that process had been lodged. You ought to have seen it, read it, reviewed it, formed an opinion, preliminary at least. Then we have this phrase, what is the business for the day or of the day? I mean, not everyone who says it has issues, but the ones who say it and mean it the way I read it, it breaks your heart. When you've sat through the night for hours and you've pored over your submissions and your authorities, or you have drafted this beautiful, well, in your opinion, submissions, and you go and you expect that this is an application that within reasonable bounds, the judge is going to rule on that day. And the first thing when your case is called is, what is the business for the day? Evidently, you do not even know what process I have filed. Not to talk of the opposition. Is that promptly, efficiently, and fairly, well, speedily as well, dealing with the matter? Thank you for those adverbs or adjectives, somewhere in between. And then we have the concurring judges, because lack of integrity or poor work ethic is not just common to the single justices. And I say this with all deference. I do acknowledge that we have some excellent judges. But of course, if we had attained perfection in access to justice, we would not be discussing these issues, and we must be bold to confront our problems. Somewhere in Accra, and it was alluded to by His Lordship Justice Che Bafo, a certain number of people sat down and gave a decision which was contrary to what was in the statute. Dare I say it was a stamp act from what we heard this afternoon. What were the other members of the panel doing? Because they concurred. Please, this is an anecdote. Fictional, yes, that's the caveat. So let me leave this afternoon out. Let me leave His Lordship. But the point is that we have one too many concurring brethren. And we forget that we are human. And however competent, qualified, and diligent that a judge may be, there's a reason why certain judges sit in numbers. And it is because we need diversity in thought. And we need someone else to cross-check that which the other person has decided on. Somewhere in the capital of this country, there once was an appeal. And after judgment was delivered, the appellant had mounted the appeal because a judge had awarded special damages for a plaintiff who had failed to prove it strictly. And in addition, awarded general damages. Now, on appeal, the expectation was that the special damages, worst case scenario, that would fall. And if anything, the general damages would stand. But interestingly, the general damages was set aside and the special damages was reduced in quantum. So the thing did not sit well with the parties in that case, the characters. So they went back and they said, hang on, let's look at one or two things. Lo and behold, they look at the name of the panel members in this story, only to realize, remember it's fiction, that one of the panel members was a judge who had recused, and I won't say gender, so you can begin to conjecture. But that judge, the judge recused him or herself in the trial court on the basis that the plaintiff was was that person's friend's close sister. How did that person sit at the appellate level? Now, as part of the panel that gave this decision, such that, and this was an excellent panel. And so you wonder, is it that they started reading the record from the judgment and the submissions because the proceedings when the judge recused him or herself was in the record? The only thing that saved that panel and the respondent was that the appellant didn't pay the lawyer. And so the lawyer chose not to further appeal. Otherwise, this story might have been real. Poor case management. And so many anecdotes. Failure to assign appropriate dates, times, and duration for trial and hearing. And please, let's not forget that in as much as some judges poorly manage their cases, the people who enable that are we ourselves. So, well, in this case, also in the capital somewhere, dates were given for trial. Plaintiff flew in from somewhere. Fortunately, plaintiff finished his evidence. Plaintiff's witness comes into the box, about to have witness statement admitted as evidence in chief. Objections are raised on some part of the witness statement. Mind you, witness statement was filed at least 3 years before the trial date. So ample time, and that will lead me into another place I don't want to stray, but I believe that CI 87 Evidence Act, we need to do something. Otherwise, it defeats the whole purpose of case management. But let's come back to the story. Before we had witness statements, if someone was relying on evidence or purporting to adduce evidence that the other party objected to, do we adjourn for ruling on such an objection? Well, this one was on paper in the witness statement. So adjournment catch 'em. We come back on the adjourned date and say, oh, is it today? And the case is listed on the course list. Pray tell, what was it doing there? Yes, please, it is today. Oh, I did not get the docket. We think they take concern me for that one. But of course, I'm standing here and I'm talking. In that story, the person said, yes, sir, madam. Or yes, sir. And then the thing was, oh, but we do have additional dates. There are so many decisions, I cannot guarantee that your ruling will be ready. And so you have to come back in term time. 3 months adjournment to rule on an objection to a part of a witness statement. And I recently saw a 2019 case completion plan, practice direction, signed under the hand of former Chief Justice Sophia Kufu. Excellent, excellent recommendations. And this is contrary to it. But that's the quality of, we are in court. One would say we've had access to justice, or we are in the process. All right. The person in the story then says, can we have additional dates then? Because we've lost the day this person came to court, this witness. The objection came. They didn't even have the evidence in chief admitted. Next date we came, is it the day? So the other dates too, you are taking us, give us dates. Oh, when you come. We say, oh, by that time, the diary will be full. Push, push, push. as for the date, if I mention it, the story will be too real. But long and short is that the date is on one of those danger days that you know that proceedings will unravel, like 29 July or 23rd December. Those kinds. So what do you say? Most grateful. What kind of justice or access is that? What if the witness dies before we come back? What is the cost to the parties who have to come on this auspicious date that it's likely that nothing will happen? But why was that possible? Because the friend on the other side, it suits that person. And so on that occasion, we don't speak up. It's easy to blame the judges, but we enable it. If we all spoke up and we said, we have started this trial, the plaintiff has X number of witnesses, I am going to call so many, and the lapse in time is even going to affect your recollection of proceedings, can we come back earlier? But we do not do that. Because we are not pursuing justice, but we are placing our individual client's interest above our other duties as counsel. As for the adjournments, you know, late delivery of rulings with impunity. That brings me back to Order 41 that I read. You know, and we'll look at Rwanda if we have time. But in Rwanda, if you fail, that judgment becomes a nullity. If you write it outside, you will have to go for an extension. And how many times would you want to do that? Writing to the CJ to give you an extension, you will stop. In other places, I can't remember if it's in the US, your paycheck is withheld until you deliver that decision. And we have to begin to look at some of these things because, you know, if it doesn't bite you somewhere, you don't feel the pain of the parties who are appearing before you. Thank you. I've talked about inability to reprimand or call out lawyers, but I need to tell a story. That one too, it was 3 wise men. And you won't believe the mischief that happens when it comes to records of appeal being compiled. There's a canker now where in interlocutory appeals, which arise from an application, an interlocutory process. So you file a motion, I file an affidavit, a judge rules, and I say I'm not happy, I'm appealing. What business does every other process which did not form part of the interlocutory application have to do with the record that is now being transmitted? And that becomes a gateway for ensuring that suddenly the processes even go missing. And once you cannot transmit, you cannot have the appeal determined. And everybody folds their hands because it suits them. Now you go before 3, yes, and you say, I have come here before. So you try to rectify. Sometimes you say these processes are not germane to the appeal. Give us an order for rectification to remove them so you proceed. Oh, but how does it affect the appeal if it's inside? The fact of the delay, that because it has been added to the list of documents to be included and they cannot be found and you cannot proceed, is completely lost on the judges. And this is why I recommend that every aspiring judge walk in the shoes of a practitioner. I'm not saying it's a prerequisite to being competent to sit, but feel the pain of a practitioner, feel the pain of a party, and when you make rulings, it will impact on how you deal with it. So, in one of these rectification applications, we are saying, look, these things cannot even be traced, and they are not germane. What did I say we? Please, it's the people in the story. And the other side swears an affidavit and says, oh, the documents have all been found. No need for rectification. Let's go and put. We go, registry says nothing. Why am I saying we? It's the people. Then, yes, thank you, 3rd person plural. And then the thing comes back again, and the other side files an affidavit and say, oh, actually, it was only one and not all. And you draw the attention of judges that we are not just here on the merits of the application, but this is an officer of the court who swore on oath that everything had been found and they are now swearing the contrary. What did the judge in the story say? what is the relevance? And it's like we have a lot of cases to call, and I said, wow, very well. I take a cue. That was not me. It was my clone in the fiction. But we just read about the Judges' Code of Conduct and the fact that during proceedings, when it comes to their attention that there has been a misconduct by counsel, they are supposed to report. But it appears not to be something that agitates. My Lord Justice Amegache, I notice your presence. I'm not referring to you. I did not. Then there's incompetence. I mean, these things, they straddle, they overlap. But one of the things that is most painful to encounter in a judge is indecisiveness. And it is a key indicator of incompetence, because your incapacity or inability to make up your mind is because you do not understand and appreciate the issues before you. You have not applied yourself or sought resources to enable you take a decision, and it is incompetence. And you do that, it makes the whole process costly. So that's one of them. And inability to understand, even when you don't know, and higher authority is being urged on you, that one too becomes difficult to apply. And it's one of two things. It's either you are incompetent or you've been influenced, because certain decisions, with all due respect, defy logic. Then, poor quality of decisions. You will notice that certain places, the thing goes, then it's set aside. It goes, then it's set aside. So the question you have to ask yourself is, how does this keep happening? Who is watching? How is it that not too far from Accra, some Equiamansa and Kwame Wusu have a case pending, and for the entire legal year, Equiamansa was to be cross-examined. She had what you call the sealing of the mouth. And for the rest of the legal year, every trip to that court outside Accra was just for a date. Thank you. And 80% of those adjournments was because a judge did not sit. And 20% when that judge sat, we indulged, oh, I have a running stomach. Yes, the other party, because you see these days, there are all kinds of strategies that lawyers adopt in defending suits. Some of them is for parties to die out, especially when they are in possession of your land. They know they are not going to win the case. So the best bet is to use the system for however long and go all the way up and come down again. So I ask, if a judge understands their judicial oath, that you sit to dispense justice promptly, efficiently, fairly, and through no fault of yours, you are incapacitated, why will you not yield? And then everybody, look at the risk of even driving back and forth. Granted that the party has chosen a lawyer in Accra. It's their prerogative, it's their right. But the risk associated with appearing, the preparation that goes into it, because that day, even though you went and came and there was no proceeding, it's not free for the client. They are paying. And you comfortably lie in your sick bed, comfortably in quotes. I have no sympathy for such a person, because I see what it does to the average client. Lack of compassion. We just award costs. There are rules that provide guidance on costs, and I'm looking at it both where it's excessive and inadequate. You can do a whole trial and then, oh, but they are related. Not when it's a company and we are fighting over shares. 2,000 cedis. Those things aggravate some people in the story. Then there was a new one where lawyers appear in a suit that is yet to be ripe for trial. Maybe there's an application pending. Both counsel are there, processes have been filed, but judge says, I'm striking out the suit because the party is not present. I ask myself, what is the overriding interest in dealing with the matter? And I understand it is done pursuant to Order 37, adjournments and delays. The lawyers are before you in a civil suit. If for nothing at all, we are just coming out of COVID. We were seeking to decongest the courts. What would the parties' role be beyond parties present? What else would that party do if they came to court? And then you strike out the suit so that this person has to now restore it through an application to relist or file a fresh suit. That costs money. If they were getting close to the list of fresh cases to be heard, they are now back at the end of the queue. Where is all that? Where is that? I'm also from Kumasi, by the way, with Fanti mixture. Then unrealistic imposing burdensome administrative functions. Why should it be my duty to ensure that there's affidavit of service on a court docket? My client pays court fees, we pay a service charge, and I do everything in my power to make sure that the process gets into a bailiff's hand. I now have to go chasing somebody in the bailiff section to get a copy of the affidavit of service before I will be heard. Between me and the judge, God have mercy on me next time. But it is your fault. I'm only a mouthpiece. Who has the coercive powers to summon the registrar or the bailiff and say, why is the affidavit of service not on my docket? And yet, every now and then, yes, sometimes circumstances are such that the matter has to be stood down and we have to go searching for it. But really, what about unrepresented parties? And I'm not saying all judges do this, but on a few occasions, I've observed the condescending manner in which pro se litigants are addressed. Look, our bread is buttered by people retaining our services, but that does not mean that if someone chooses to represent themselves, they do not have that right, or that they should not be accorded the courtesies. We are not saying the judge should be partial, but sometimes the statements, and especially when they miss Civil Form 6 and its implications, even if they've lost the chance and they are going, the way it will be explained so that they can walk away appreciating that it is through their mistake and their lack of knowledge. Because legal aid is not what it's supposed to be. And apart from some Shylocks who have money but will not engage us, there are some genuine cases where people really cannot afford the services of a lawyer and they must show up themselves. So, if that person comes and you say, where is my affidavit of service? Say, I have paid, I have filed. And sometimes that can result in an adjournment that overreaches the person's interest. Because they might have filed an injunction application, but nobody has told them that they should take certain steps or that they can now cite someone for contempt. By the time that particular unrepresented party finds the affidavit of service and you rule on that injunction application, there may be an edifice standing on the land. Yes, commit that person for contempt, but we all know the likelihood is that they may eventually not even recover possession of that land. That person will move heaven and earth with all the resources that they have to keep them out. So, recusal. And that one has to do with a client who wrote to some people who represented that client, a foreign client, and said, but we went to your highest court and a judge recused himself that there's a lawyer in the matter who was a former partner. But when they called the review, that judge appeared and participated in the review ruling against us. But look, we found another case in which that particular judge sat on the panel, and guess who was on it as a lawyer? The former partner. So we want to understand, Mr. Whoever, advise us. How is it that somebody recused themselves, came back on the same matter, And then there's even another case where there was a reason for that same recusal, but it didn't happen. And the people in the story said, we don't know. Sometimes these things, case overload. So I dealt with judge induced. Now external, the one that is not your fault. The system is such that hardworking judges who clear their load seem to get yes. And so, yes. Or some too, they are doing their best, but the load, it's never going down. And I understand that some of us, because we perceive certain courts to be more effective, we file multiple claims. Same case. In one of them, we will leave out a party's name or we'll make a mistake. Till we hit the court that we like, then we withdraw all the others. People are doing that. Then, but please do not do that. It is not fair to those of us who allow the system to assign our cases. Then we have lack of resources. You can have judges whose air conditioners malfunction for 2 years plus. How are they supposed to sit in their chambers and work? Because alongside this, you have a system where they sign in and sign out when they come. So if this particular judge goes home, the perception is that, they are not doing any work. And the one who is staying 9 to 5, but if only time, the longevity of how you stayed in your chambers was a measure. So then, as for the absence, it cuts both ways. And then, of course, you and I, mischievous counsel, who file all sorts of indefensible processes. So, what system is in place? Because the question, because of these stories that I heard from the people, I was asking myself, who watches the watchman? How is it that this court outside Accra, please don't sleep while I'm talking. Me, I'm a teacher. If your eyes are worrying you, open them. I'm taking liberties here, but I plead with you. Tarry with me. In class, I say that the devil is blowing on your eyes, but resist him with all your might. So I asked that, how is it that a whole legal year, a case that is going through trial is adjourned and it doesn't raise a red flag? It must take those people to file a petition. And it's not everybody who wants to petition the Chief Justice. Not because he will not respond. The few times I have petitioned, I have been fortunate to get swift responses and favorable ones. But then, whatever system is in place clearly is not catching these lapses. So, my inquiry tells me that judges file monthly returns, but not all courts. At least the appellate courts do not. And that's why some people can keep concurring, and we will not know that that's all that they do. These monthly returns will cover how many judgments the judge has written or rulings, how many cases have been referred to ADR. And there was one thing that I skipped: coercion of parties into settling where matters will not admit of fair settlement. And you find that it is the people who see that, this case is complex, I don't know where to pass with it, you will settle. You won't get it in express ways, but in that, once upon a time, you will settle. So, these monthly returns will also include cases that have settled through ADR. But then I asked, so after that, what? Oh, there will be an annual report which will capture the data that was collected. I understand there's a mentoring system in place. My Lord, do you have a mentee assigned to you, if I may ask? About 4, so it's fairly new. I'm grateful for just before the vacation. So that's a new innovation that has come in. I understand that there are court user service. Has anybody ever filled one of those, or have your clients filled court user service about their experience? All right, so that is also supposed to be one of the things. Attendance sheets, which I understand are given to the registrar. We have the Public Complaints and Court Inspectorate Unit. And then, of course, sending petitions to the Chief Justice. But in my humble view, we can do better. So earlier I talked about ensuring stricter compliance and better use of our existing rules. I mean, when you go for application for directions, it's done in such a perfunctory manner in most courts, only to come and bite us in the course of the trial or at the end of the trial when you have to write addresses, and you see that 8 out of the 10 issues had nothing whatsoever to do with the suit. But it is at that stage that all those irrelevant things must be pruned and narrow down on what is really relevant. And sometimes there are matters to be set down for legal arguments. There's a story where that was done, and after they wrote the submissions, the decision making was difficult. So they said, let's try everything. But in Rwanda, court proceedings are regulated by law number 22/2018, which of 29th April 20, and Article 16 of that law provides that all cases introduced to the court shall be tried in a period not exceeding 6 months, starting from the date the court received the claim. Otherwise, the president of that court shall explain to the president of the Supreme Court in writing the reasons thereof, and shall also inform parties to the case. Food for thought. Also, by Article 18, parties who intentionally delay the proceedings are liable to a civil fine. By Article 132, all judgments must be written and pronounced within 1 month period of the closing of hearings. Failure to do so may lead to disciplinary action being taken against the trial judge. However, if the pronouncement of the judgment does not take place within the 1 month period, for justifiable reasons, the president of that court shall report that matter to the immediate superior court and ask for an extension. So there are measures that will motivate or incentivize a judge to keep within time. Let me raise my hand and say, I did a trial recently. I filed my address the day before judgment. Yes, it happens. I'm not a saint. This one is a real story. This one is me. Yeah, the other ones. But that judge delivered her judgment. Glory be to God, we still won. But what I'm saying, me, I'm not a judge. That's why I'm a lawyer. And I'm staying on this side. But when you go and sit there, so we'll all come and do my lord, your ladyship, and bow and do obeisance, please, the rules you must comply with. Even if you are going to exceed, we must all know that that's not the norm. The Constitution of the State of California provides in Article 6, Roman numeral, Section 19, that judges are to deliver judgments within 90 days after close of the case. It also includes a sanction that a judge of a court of record may not receive salary while any cause before the judge remains pending and undetermined for 90 days after it has been submitted for decision. In other words, a judge's paycheck is contingent on timely decision making. In the state of Indiana, in the event a court fails to rule on a motion within 30 days after it was heard or after it was filed, if no hearing is required, upon application by an interested party, the submission of the cause may be withdrawn from the trial judge and transferred to the Supreme Court for the appointment of a special judge. Look, I know we have provisions that say you write to the CJ and then they will give a date and date for date. I mean, apart from maybe why didn't you write? What else? So we need to move beyond that. And I also agree with those who hold the school of thought that the business of delivering justice is like providing goods and services, and that it is important that we measure performance, because what gets measured gets done. And it brings me back to all the issues, or some of the issues that I have highlighted, that if there was an effective performance measurement mechanism and performance management mechanism in place, should not be possible, or at least not at the level that it attains. Time. Okay. So let's look at some of the reasons. I think, for instance, that there should be targets set across the board. As far as I'm aware, all High Court judges, all Court of Appeal judges, all Supreme Court judges draw the same salary. So we must all have targets that at the end of every month or every quarter, you must return 6 judgments, 10 rulings, whatever other ADR settled. And it shouldn't be that I just submit monthly returns and at the end of the year I get a report. At the end of that quarter, it's not just that. Let's look at the duration that cases have been in my court. What is the ratio of how quickly I'm finishing and replacing those cases, case turnover? You know, what is the clearance rate? You've seen all those things because age of the proceedings. Sometimes, yes, you will write 10 judgments, but how do we know that it's not taking 10 years before those 10 judgments came? Meanwhile, someone else is writing 50. Are we looking at how those decisions stand up on appeal over a period of time? Who is coming back to appraise? First of all, you must appraise yourself, set some targets, and then together we decide that this is it for this court. Let your peers, who may not have they don't want to report, but at least they know. Let them also appraise you. Let your subordinates, your court staff, because look, they have experience. Many judges go through those courses and they know what the standard is. And then perhaps your superiors. Then of course the court user survey that I hear is supposed to be in place. Let you and I and our clients be given those surveys. Let them ask us, because another thing that I think must be measured is appropriate behavior of the judge, which aligns with the code of conduct and not just intelligence. Because for a judge, yes, competence is key, but character, all of them have to be of high moral character and proven integrity. So we must have indices for measuring that as well. And I will skip the others and end with a whistleblower policy. Small companies even have that now. There's a reason why at a forum like this, one can have the liberty to tell anecdotes about fictional real people. Yes. There's a reason why from time to time we may petition. But if there was a whistleblower mechanism properly set up, I mean, if you like, let's start it internally just for the judiciary itself. That's what England and Wales have. And then eventually look to extending it to stakeholders like court users. Set it up so you have an external person manning and receiving it. And limit it to complaints that have to do with incompetence, misconduct. And let's see if some of these things will not be brought to bear for action to be taken. Thank you for your attention.